The subcommittee will come to order. Without objection, the chair is authorized to declare recesses of the subcommittee at any time. Welcome to this morning's hearing on counterfeits and cluttering, emerging threats to the integrity of the trademark system and the impact on American consumers and businesses.
Thank you for inviting me to be a witness today. I am Jeannie Fromer, professor of law at New York University School of Law, where I teach and publish on intellectual property. My remarks on trademark depletion and clutter draw on research with Professor Barton Beebe, also of NYU School of Law. Along with our written testimony, I have submitted our recent Harvard Law Review article, Are We Running Out of Trademarks? An empirical study of trademark depletion and congestion. Trademark depletion is the term we use in our article to describe the decreasing supply of unclaimed, competitively effective trademarks available to new market entrants. Although trademark law has operated on the assumption that there exists an inexhaustible supply of unclaimed trademarks, the empirical results we report confirm the opposite. It is becoming increasingly difficult for new businesses to find a trademark that is competitively effective, but that has not yet been claimed by another business. To give you a sense, now, nearly 3/4 of the time we speak, we are using a word that someone has already claimed as a trademark. Also, a majority of Americans carry a surname that is already claimed as a mark, meaning that they might have been born too late to claim their own name as a mark. Even using a conservative similarity matching protocol, nearly all the words we use on a daily basis and the surnames of a high proportion of American people are already registered or are confusingly similar to an already registered mark. Meanwhile, new applicants are increasingly shifting toward coined words and longer, more complex, and thus less effective marks. Yet even these efforts are increasingly failing. PTO refusal rates for confusing similarity to an already registered mark continue to rise. This problem is particularly acute for small businesses, which typically lack the sophistication and resources to find unclaimed, competitively effective marks and prosecute those marks to registration. Trademark depletion undermines trademark law's goal of promoting fair competition by raising entry barriers for new businesses with regard to finding and claiming unclaimed, competitively effective marks. Trademark depletion has been exacerbated in recent years by an inflow of applications originating from China. Media reports suggest that a significant number of these applications contain fraudulent statements of use and therefore fail to meet trademark law's use in commerce requirement. In fact, commercially available reverse image search technology reveals that some of these specimens of use being filed are clearly fraudulent, yet are not detected as such by the PTO. When these applications are allowed to proceed to registration, they contribute to clutter on the register. Clutter is the term trademark law uses to describe marks that are registered but are not actually used in commerce. It is important to declutter the trademark register both to abate rates of trademark depletion and to maintain the register's integrity. Doing so ensures that barriers to entry are not heightened in a way that protects incumbent businesses at the expense of new entrants and protects large businesses at the expense of smaller ones. To address the problems of trademark depletion and clutter, we support a mix of reforms to trademark law, including less costly processes than current possibilities for re-examination, cancellation, or opposition, which typically cost in the 6 figures, to clear the register of marks that are not being used in commerce, increase fees charged to non-small businesses to register, maintain, and renew their marks, and the institution of a lower standard for fraud on the PTO rather than the current heightened standard. Thank you, and I look forward to your questions.
Professor Fromer, do you think there are gaps in the current trademark law that will prevent the PTO from effectively addressing trademark cluttering?
Thank you. Yes, I do. I think that one of the challenges that currently face businesses that are trying to operate is the ability to cost-effectively remove unused marks from the register. The studies that are out there indicate that the average cost of a trademark opposition ranges from $150,000 to $500,000, whereas another one estimates the median cost to be $95,000, which means that many small businesses will throw up their hands and give up before actually challenging a mark that is not being used. In addition, as we heard in the previous panel, I think it would be helpful for the PTO to have more authority, take more initiative to audit crowded parts of the register to cull marks that are not being used.
Thank you. What are the impacts on consumers for trademark cluttering?
So consumers are thought to have the advantage from trademarks of having minimized cost. That is, that they can locate quality products more effectively through the shortcut of a mark without having to investigate that. The more crowded the trademark register is, the harder it is for consumers effectively to do that because marks are closer together. There are many more marks they have to process, and they have to try to remember marks that are more cumbersome, longer, more complex. And so trademark law does not do its job of helping consumers in the way that it could without a less crowded register.
Professor Frommer, I appreciate your focus on the dangers of having unused trademarks cluttering up the register. My understanding is that process for removing them is burdensome, especially for smaller businesses. Can you just talk me through the cost of challenging trademarks that appear to be fraudulent or at least ineligible for registration using the process that's in place, the opposition process at the Trademark Trial and Appeal Board?
Sure, thank you for the question. So the current two processes for challenging these fraudulent specimens of use are generally opposition and cancellation. Opposition, for the most part, has to happen within 30 days of publication of a trademark, so it's a limited window that third parties have to be vigilant for. If they miss that window, they won't be able to oppose. That's a limitation of opposition. Cancellation can happen on any grounds within 5 years of registration, but on much more limited grounds after 5 years, which is another limitation of cancellation, not to mention the cost that goes into this, which I think is a challenge for small businesses. It would really be helpful to have a ex parte possibility that is much lower cost in nature to challenge fraudulent or unused marks.
Got it. Professor Frommer, does the PTO have the authority to remove a mark it should not have registered, or does the agency need additional statutory authority to remove fraudulent trademarks that it made a mistake with?
I think that the PTO needs to be given more statutory authority in this instance. There's a lot of power until registration happens. After that, power becomes much more limited. The only exception to that I know of is the recent permanent auditing program that's put in place, where the PTO has been able to get registrants not using their marks in whole or in part to delete parts of the registration. But it would be nicer to see that expanded more broadly, given how many unused marks seem to be on the register.
So if Congress gives the PTO more authority to remove fraudulent trademarks, what should we do to consider including, or what should we include in that legislation to ensure that the PTO is not going to misuse that authority to remove properly granted trademark registrations? I mean, there's a big distinction there, right?
Yeah, no, it's a wonderful question because, of course, this has to be balanced. And I think one of the things that has emerged today is that the PTO is looking forward and becoming better, which is great, at using technology, instructing examiners to deploy certain resources or lines of inquiry. But that's not backward looking at all, which means that things end up sitting on the register that if they had been applied for now might not have been. And I think it would be helpful to instruct the PTO to, at least in certain random audits or audits in crowded areas of registration, to deploy these new techniques as well in this backward-looking way to remove unused marks from the register.
Thank you.
I want to thank each witness for your testimony today. All of your, without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. And once again, thank you very much for your time and attention and your testimony today. With that, the hearing is adjourned.